State your name. My name is Daniel McJew, for the record. Your Honor, you are choosing to represent yourself in this matter, sir. Yes, sir. I need to advise you that in this case, you are charged with assaulting, resisting, or obstructing a police officer. This is considered a high court misdemeanor or, in certain circumstances, felony. It carries a penalty of up to 2 years in jail, a $2,000 fine, plus court costs. Do you understand the nature of your charge? I understand the charge. I also need to make you aware that representing yourself carries significant risks. You understand what I'm saying, sir? I'm not afraid, John. Do you understand what I just said? That there is great peril in representing yourself in court. I comprehend what you are saying. All right? Here's the deal. Either you answer my questions directly, clearly, and properly, or this is going to drag out. And I won't make the other people in this courtroom wait for your word games. So while you decide how to proceed, I am going to have you take a seat. We will pass your case for now, and when your matter comes up again, you will learn how to operate properly in this court, plain and simple. Have a seat, and you might want to wipe that smirk off your face while you're sitting down. State your name. Good afternoon, Your Honor. My name is Daniel Liu. I have stated the admonishments to the defendant who has chosen to represent himself. I informed him of the maximum penalties, the charges he faces, and the risks involved, sir. I will ask you again. Do you understand that there can be serious peril in representing yourself? I fully recognize and acknowledge the seriousness of the charges, which include allegations of no, sir. My question is, do you understand that there is real danger in handling your own defense? I recognize what you're saying, and I am fully prepared to proceed with this matter. Will you just answer my question? Do you understand the risk of representing yourself? I recognize that. Okay, stop there. You recognize? Recognize. Do you understand that in any proceedings, the court will hold you to the same standards as an attorney? At this point, this is a textbook example of why courts strongly advise against self-representation. The judge is practically begging him for a simple yes. I understand, but instead, the defendant plays word games. I recognize. I understand. What may sound clever to him is only frustrating the court. In law, precision matters. If you cannot answer a judge's direct question, how could you possibly handle rules of evidence, objections, or legal strategy? This isn't about being stubborn, it's about risking your freedom. Viewers, would you let the court force a lawyer on him, or let him crash and burn on his own? As if he were a practicing attorney, he would be held to the rules with no leeway, no favoritism, no bias even if representing himself. Do you understand, sir? I recognize what you're saying. You know what? I don't understand why you refuse to answer directly. I need a clear answer, whether you understand. Not whether you recognize the words. Do you understand me? I understand what you're saying. You want to, Your Honor, have a seat. Have a seat. I haven't had a seat. You can play games with me all day. I have all day. Have a seat. The other defendant is in custody. I realize we're now at least caught up within an hour. I think anyone here probably wants a break. So we'll take 5 to 10 minutes and then call the cases. Court will stand. Afternoon, Your Honor. Daniel McJew. All right? Mr. McJew, you are representing yourself. I have already advised you of your rights and the charges. You are aware that there is significant peril in self-representation. The court will treat you the same as an attorney, applying all rules of procedure and evidence. I will not give favors or clarify things for you. If at any point you want a lawyer and cannot afford one will be appointed. I will presume you understand English and the words I've spoken. So we will not get caught up in semantics. Having said that, what are we doing with this case? I'd like to move for an evidentiary hearing or a preliminary examination. Do you wish to have a preliminary examination? Yes, sir. Do the parties have witnesses available? We can try, Your Honor. But before moving forward, may the court address discovery matters. I am aware the defendant filed a writ of mandamus with the Court of Appeals in Michigan. Sir. The court will presume that you know the rules of procedure and the Michigan rules of evidence. I will not be giving assistance beyond what the law requires. What I'm trying to say, Your Honor, is that I do not fully understand the charges against me. I believe my rights have been violated. And although the prosecutors served me the discovery packet on the 27th of last month, I have not received additional evidence or claims showing that I violated anything. So I am here waiting for that information. I do not understand the charges. Waiting for what to occur. Under my rights to due process, 4th, 5th, and 6th Amendments, there must be substantiated evidence to accuse me of assaulting a police officer, obstruction, or resisting arrest. I take these charges very seriously, Your Honor. I have already lost custody of my son, and I want to ensure justice and equity are served, sir. I asked if you understand the charges. Whether or not you agree is not the issue. The question is, do you understand what you are charged with? I do not understand. Your Honor, is there any other reason besides what you've said for not understanding? I could elaborate further, Your Honor. I am still waiting. I wish you wouldn't. I just need to know why you don't understand. I am not asking whether you agree or think you are guilty. I'm asking if you understand the charge. Can we agree to disagree? No. This is not a game. You play by my rules. You are saying that you must say the words "I understand." But I am not requiring you to say anything. I am not going to play this game. You are playing a game. Do not interrupt me. I am going to give you a week to consider. I am not going to call this case multiple times for you to engage in semantic games. This matter is adjourned to December 12, 2024. At 9 a.m., objections are noted. Bond will continue. You may leave now. Do I not have the right to counsel? If you wish, an attorney can be appointed. I do not need counsel. I am presenting myself. I was the only one there that day, and I know what happened. If you wish to be represented by counsel, you may. Otherwise, I will proceed with you representing yourself. This court calls the case State of Michigan versus Daniel McJew. Good afternoon, Your Honor. Daniel McJew, representing himself. I have already apprised you of your rights. You face resisting and obstructing a police officer, punishable by up to 2 years in jail, a $2,000 fine, and court costs. Representing yourself carries great risk. I will treat you the same as if you were an attorney. If you cannot afford counsel and wish to have one will be appointed. I will presume you understand everything I have said. Now, how do you wish to proceed? I'd like to move for a preliminary examination. Do the parties have witnesses ready? We can try, Your Honor. But first, may the court address discovery issues. I understand the defendant filed a writ of mandamus with the Michigan Court of Appeals. Yes. That was subsequently the Court of Appeals. Contained within that, though, there are allegations that my office has violated his Brady obligations and has not provided sufficient discovery. So I'm not sure if we're ready to preliminary exam. The defendant is saying that he doesn't have a discovery. That is the concern off record I feel compelled to make. ASC's time, though, is that the people have provided, I do believe, complete discoverito, the defendant. And here's the turning point. The stat insists they've turned over everything. But the defendant argues that because a known of it clears him. Discovery must bind complete. That's not how it works. Discovery is about access to evidence, not about whether it proves or innocence. This shows the danger of self-representation confusing procedure with fairness. The judge even flat out says, "What you just said didn't make any sense." In the eyes of the court, this is a credibility problem, and it could cost him dearly. What do you think? Was he raising a valid concern or just showing he's in way over his head? And I believe that some of their presentations that were made in this writ of mandate that has been dismissed include to allege that things that have already been denied by this court should produced. Furthermore, the defendant filed a motion with no notice of haranguish to it. So there's an outstanding motion in this case as well. No hearing date scheduled. So I'm hoping that we can sort of reconcile both of those things as whether or not discovery is something to report and heaver file a notice peering to go along with. Motion that I received in this case on A22. Mr. Gu, your response. My response is that I thought this was the hearing that we were setting for the motion. So if I have to set a motion for a notice of hearing for that motion, I will do that today, Your Honor, promptly. What about discovery? I'm ready to move forward on my EWAT. I meant by my discoveryment was that there's still no exculpatory evidence as far as that. If I did anything wrong as far as anything that they've submitted. So it was improper for the wording, Your Honor. Apologize. But my ultimate goal is have the ER prosecution pre-stain their evidence against Steam. Going to indicate discovery is complete. Because I don't know what you're saying, because what you just said regarding discovery didn't make any sense. As it regards the motionum, we will hear the motion on, or the motion will be heard on date of exam with it at that point in time. So Thepipol would have their witness Cesavella on the 2nd. We can try for the 2nd. John preliminary examination in person January 2nd, 202512Y12. Noon that is before me. Thank you. Continue.